This video will describe a task that we'd like you to do in the discussion forums for this session. The subject is the UN Declaration on the Human Right to Water and Sanitation. When we teach this material in a live classroom at our universities, we typically organize this discussion in the form of a debate with a for side and an against side. In this MOOC, we'd like you to hold a debate in the discussion forums for this session. Here's the proposition we'd like you to debate. The United Nations Declaration establishing a human right to water and sanitation is a big step forward and will result in many more poor households receiving improved water and sanitation services in the future. In the discussion forum, you can choose which side of the debate you want to argue, for or against. If you take the for position, you should argue that the United Nations Declaration of the Human Right to Water and Sanitation is a big step forward and will result in many more poor households receiving improved water and sanitation services in the future than would otherwise have been the case. If you take the against position, you should argue that this is not true. Please be sure to read the 2010 UN resolution about the human right to water and sanitation, which we have provided to you. There are two interesting papers that can give you some background on some of the different perspectives about the UN Declaration. Both of these were published in the journal Water Policy. Also, if you Google human right to water and Catarina de Albuquerque, you'll find a huge amount of material. Catarina de Albuquerque was the UN Special Rapporteur on the human right to water from 2008 to 2014. There were also lots of video materials on this topic on YouTube. As background for your debate, in this video I'd like to say a few general things about the assignment of rights as one kind of policy intervention. Another way to think about the establishment of a right to water is that it gives the claimant, the person who wants the improved water and sanitation services, power to make a claim on the duty holder, and the duty holder is assigned a liability. There's a new claim that is being made on his financial resources. For example, the government of the United States has been very careful not to consent to any legal liability as a duty holder. The United States has joined the consensus on a number of United Nations resolutions that recognize the human right to water and sanitation as part of achieving an adequate standard of living that is progressively realized. In other words, it has accepted the human right to water as an aspirational goal, but with no legally binding obligations for the United States. More generally, there are three main grounds on which a presumed duty holder can deny a claim that someone has a human right to water and a claim on his resources. First, someone might agree that the claimant has a right, but deny that he is the duty holder. In other words, that the liability of the right falls on others. From my perspective, this is close to the position of the United States on the human right to water. Second, a duty holder might deny the actual existence of the right, questioning, for example, the legitimacy or standing of the United Nations or even his national government to create such a new right or entitlement to improved water and sanitation services. Third, a duty holder might acknowledge that a particular kind of right exists, but deny that a specific individual or group can claim it. For example, a particular group of claimants might be judged to be too rich or already have sufficient water service to impose a liability on the duty holder to provide better water and sanitation services. This raises another interesting issue that you may choose to discuss in your debate. What level of service is sufficient to satisfy the human right to water and sanitation? For example, is a system of public taps sufficient? If the state is the duty holder, can it impose a per bucket price for water from public taps and still say that it has satisfied the human right to water, if claimants say that the price is too high? What if the state decides to provide free public taps, but a group of claimants says they do not want public taps? Instead, they want piped private connections for the exclusive use of household members. And they say they would not use free public taps and that the vendors they use now are expensive and they know the water is contaminated, but they are convenient. Should the state be obliged to provide a lower level of service that households do not want in order to satisfy the human right to water? Or is the state obliged to provide subsidized water from private pipe connections? There are also interesting questions about the dynamic obligations of duty holders that you may want to address in the debate. For example, suppose an international organization accepts that it is a duty holder and provides free latrines to poor rural households in a region where open defecation is common. For argument's sake, let's assume that rural households stop open defecation practices and use the donor's latrines. But suppose that after the latrines are filled up, households do not have the money to have them emptied, or simply choose not to do so and return to open defecation. Is the duty holder's obligation fulfilled, or is the donor obliged to arrange for the latrines to be emptied? In other words, does the obligation exist into perpetuity, or is it time-limited? Another question you may choose to discuss in the debate is the legal enforceability of the human right to water. Some have argued that poor households without sufficient water and sanitation services can sue their national governments for the enforcement of their rights. This could be either in the national courts or at the International Court of Justice at The Hague. Would you support such legal action? Do you think the courts have an important role to play in deciding on the scale and type of investments needed to improve water and sanitation services? Another area for your discussion forums might be the distinction between negative rights and positive rights. The United States Bill of Rights provides examples of negative rights, things the state should not do because the rights holder has the liberty or freedom to undertake these actions. For example, in the United States, our Bill of Rights protects citizens from intrusions by the state on our freedom of speech and freedom of religion. Similarly, citizens of the United States have a right to not be subject to unreasonable search and seizure, double jeopardy in a court of law, and self-incrimination. On the other hand, the human right to water and sanitation is best characterized as a positive right. The state or duty holder has to take a positive action to do something. In this case, to build and maintain water and sanitation services. In the case of the human right to water, the duty holder has to spend funds to ensure that the claimant has the benefit stream of water and sanitation services. Of course, the state may also have to spend some funds to ensure negative rights are protected, but certainly not to the same extent as the provision of a daily service to all the individuals in a population. For example, people may never need a jury trial, even though they have a right to one, but people need water and sanitation services every day of their lives. If you're interested in pursuing the implications of this line of inquiry in the discussion forums, you may find it useful to read Isaiah Berlin's seminal essay, Two Concepts of Liberty. This essay was first presented as a lecture at Oxford University in 1958 and is widely available. One place you can find it is in Isaiah Berlin's book, 4 Essays on Liberty. It is one of the 4 essays. We hope you have fun debating these issues on the discussion forums. Good luck.